Welcome again. This webinar is hosted today by the Women's Human Rights Education Institute. Founded in 2004, the WHRI has been offering CEDAW and international women's rights capacity building programs to women's human rights defenders from around the world for almost 20 years, including in-person and online learning programs focusing on women's rights advocacy. We are passionate about CEDAW as a tool to support feminist activism. The topic for today's webinar is CEDAW, the UN Convention on the Elimination of all forms of discrimination against women. Our panelists will explore the manner in which CEDAW comprehensively addresses violence against women in its framework and in its practice. In recent years, some voices calling for an international treaty on violence against women have emerged. In our view, these calls for a new so-called Every Woman Treaty fail to account for the well-established human rights norms and decades of jurisprudence of the CEDAW Committee, which addresses myriad forms of violence against women. We are hosting this panel today because we want more women to engage with CEDAW, to understand it, claim it, and use it. We are excited that more than 400 people register for this important topic. Un recordatorio, si se nos están uniendo personas en español, estamos con traducción, pueden escoger a la parte baja de sus pantallas el idioma español para escuchar esta intervención en español. We are very pleased to have an incredible panel of speakers with us today to speak to this issue and the primacy of CEDAW as the Every Woman Treaty that already is. Our first speaker will be Amanda Dale. Amanda is an international human rights scholar and activist specialized in women's human rights and violence against women. Amanda is currently on the board of Inner Paris in the Canadian Centre of Legal Innovation in Sexual Assault Response and the Canadian Femicide Observatory for Justice and Accountability. We also have Patricia Schultz, who's a lawyer specialized in gender equality and non-discrimination against women. She's a former rapporteur and member of the CEDAW Committee, UNRISD Senior Research Associate and former director of the Swiss Federal Office for Gender Equality, FOGE, and one of the editors of the revised version of the CEDAW commentary that is forthcoming. Patricia and Amanda co-authored the paper on CEDAW and violence against women in response to the so-called Every Woman Treaty movement that they will speak to today. Our third speaker is Marion Bethel, currently an expert member of the CEDAW Committee, attorney to the bars in England, Wales, and the Bahamas. In 2014, Mrs. Bethel was the first Bahamian to receive the CARICOM Award for her contribution towards gender justice, culture, and the socioeconomic development of the Caribbean. Marion will share her insights into the centrality of gender-based violence against women and the work of CEDAW Committee today. We are also very pleased to introduce international women's rights jurist and activist Alda Facio, who will act as today's discussant. Alda co-founded the WHRI and is a former expert member of the UN Working Group on Discrimination Against Women. She has worked to promote CEDAW for many decades and will engage with the panelists through comments and questions after their initial presentation. The format of this meeting will be that each participant will speak for 15 minutes on this important topic, after which Alda will engage in discussions with them and raise questions with our panelists. The panelists will have the opportunity to dialogue further and share their thoughts and in discussion with one another. There will be no public Q&A session during this webinar. Si alguien más se nos está uniendo ahora, les recordamos que esta sesión tiene interpretación simultánea al español. Van a la parte baja de sus pantallas y dan clic para escoger la opción español. So, without much further ado, please join me in welcoming Amanda Dale to kick off the conversation. Welcome, Amanda. You're muted.
My apologies. Thank you very much, Patricia. It's my pleasure to be here today with all of you. And I think what I will do is just give a little bit of a background as to what we are doing here today, and a little bit about why Patricia Schultz and I wrote the article that prompted this session. The good news is that the group that is proposing the treaty, the Every Woman Treaty, has, in our view, misunderstood the context of protections in CEDAW and has vastly underestimated them, and indeed, I would argue, factually misrepresented them. This means that we have in place greater protections than many people think. And I'll begin to indicate the ways in which that misunderstanding could put in peril the things we already have in place. But let me situate myself first. I'm an activist in the Canadian and international contexts. I've been working on and delivering direct services for and to survivors of gender-based violence for 40 years. I've been calling the state of violence against women and gender-based violence a global pandemic in my work with both media and NGOs since the WHO declared it as such in 2014. For a decade, I was executive director of Canada's only gender-based violence legal counseling and language interpretation clinic, which also achieved UN standing. This is relevant because my interest in this issue is not theoretical. I met Patricia Schultz when I was doing my PhD in law on CEDAW and its intersectional approaches to international human rights protections. And subsequent to that, we struck up a correspondence. Subsequent to my PhD submission, I became aware of an initiative to create a new treaty on violence against women as part of my work leading and advising NGOs and INGOs in Canada in 2019. As I understood it, the Canadian state at that time was being requested to support the development of a new treaty, specifically on violence against women. I looked into it further out of curiosity, and I found a very puzzling project that made what I can only describe as a surprising and incorrect claim at that time in 2019, which was that, quote, currently no legally binding instrument in the global level exists to hold nations accountable for preventing and addressing violence against women and girls. That was 2019. When I researched further, I discovered a group supported out of Harvard University in the United States that had initiated this. Since that time, Patricia and I looked into it further, and they have now elaborated their position to claim that there are normative gaps in the coverage of CEDAW and not the original statement of no binding agreement. But they say now that there are gaps in CEDAW and related instruments. So as an activist and as an international human rights scholar, I felt it was important to harness this energy, this really good energy to fight the scourge of violence against women, the global pandemic as we know it to be, and to channel that outrage into strategic and legally accurate advancement of the rights for women to live free from violence. So I began writing about this issue. And I guess generally I want to say at the top, before I go into a bit more detail, that there are a variety of legally binding instruments that oblige states to protect against gender-based violence. But premier among them, and given the time we have today, CEDAW and its jurisprudence, specifically General Recommendation 19 and its update, General Recommendation number 35, are key to understanding the foremost protections against violence against women. This is a legally binding framework, and it has been underscored by Joint General Recommendations 31 and number 18 from the Committee on the Rights of the Child on Harmful Practices. Okay, so what do I mean by all of this, and how is it related to the project of the Every Woman Group? So the Every Woman Treaty Group situates their project within a justifiable outrage against the global pandemic of violence against women. I fully agree that the global pandemic of gender-based violence and its deepening under the conditions of backlash and COVID-19 pandemic measures makes it a compelling and potentially galvanizing issue for feminists to be active about around the globe. Having looked into it in 2019 and since, let me detail what my curiosity about and research into this initiative turned up. I've explored and written about this 3 times. At first in 2019, most recently with Patricia Schultz, my sister panelist for Human Rights Day in 2021, and in the middle there somewhere for the Oxford Human Rights Hub. This is what our research and the premise for today's session turned up. The proposed new Every Woman Treaty, contrary to its claims, does not represent progress in legal protections for women experiencing violence. Why is that? On the contrary, it is a distraction from the crucial task of implementing the protections that are already guaranteed by international human rights law at the local and national levels. The Every Woman Treaty Initiative is flawed in several ways, which we explore today, but fundamentally, it is founded on a misunderstanding of the nature of the role of international human rights law. The initiative both weakens the present system of international legal protections against violence against women and campaigns on a false promise to bring an end to the worldwide global pandemic of gender-based violence through the addition of more law rather than the national implementation of existing norms. And this latter point is crucial. We will explore this further today in our conversations. Starting off, what does all this mean? The weakening of the present system, why is that? Our detailed analysis of the Every Woman Treaty campaign and the draft treaty that they have released reveals that it rests on a mistaken analysis of the present set of protections against gender-based violence. The Convention on the Elimination of Discrimination Against Women is a treaty that protects against all forms of discrimination against women. As such, the interpretation of the treaty within evolving norms of international human rights law sees violence as a serious form of discrimination that gives rise to and underpins all other forms of discrimination that women experience. It is both a standalone harm and linked to all the other harms that are enumerated in the treaty. Every Woman Treaty denounces what it describes as normative gaps in this set of protections, and it thereby disregards the evolution that has taken place in law since 1989 when the treaty was drafted, and derisively refers to this proper role of progressive lawmaking as retrofitting the treaty. Gender-based violence against women is not mentioned in the CEDAW Convention in the articles that you see when you just read the treaty on its own. But it was authoritatively interpreted by the CEDAW Committee in its groundbreaking General Recommendation 19 and adopted by the General Assembly, which is the primary source of new international law, as a form of discrimination against women, prohibited by Article 1. This is Article 1 of the CEDAW Treaty. This article is key. It means that gender-based violence falls under the ambit of all of the CEDAW Convention articles. So contrary to the claims of the EWT folks, the Every Woman Treaty folks, states are bound to act on gender-based violence against women. Article 2 of CEDAW sets out the obligations of states to address the needed legislation on gender-based violence, and the practical measures such as finance, training, shelters, protection orders, data collection, etc. This protection is required not only through criminal law, but also within different fields of public policy, such as in education, work, media, and politics. States are accountable for gender-based violence against women stemming from their acts, those of their agents, and also of non-state actors, which means the forms of gender-based violence that take place behind closed doors in intimate partnerships. When the state knew or should have known that gender-based violence was or might be occurring or had occurred, and the state could have prevented it. And this is known in the literature as the due diligence principle. States must also ensure a gender-sensitive, non-biased, and competent justice system. This applies to the police, social and health services, and other state agents. That includes migration officers, teachers, etc. States must also take all measures to eradicate or modify norms, customs, and practices which condone or enable gender-based violence against women, and thus they have an obligation of prevention. Such obligations apply to all fields of action which the state must take all appropriate measures to realize. Another way to think of it is that CEDAW is a blueprint for a feminist future that we as feminists need to use to advocate with in each of our states and countries. The CEDAW committee, which we are privileged to have two experienced former and current members from with us today, details for each state, according to specific conditions in that country, what needs to change to meet that feminist future. A treaty that would divorce violence against women and gender-based violence from all forms of discrimination, such as that suggested by the Every Woman Treaty Group, would sever gender-based violence against women from this gender equality and non-discrimination normative framework. It is also this very non-discrimination context and its interpretation by the committee that provides all the elements that the Every Woman Treaty mistakenly claims are missing from CEDAW, such as the obligations to civil and political, economic, social, and cultural rights. The implementation of these rights is key to guaranteeing that women and girls have a life free from gender-based violence by addressing the root causes of gender discrimination, those things that make women vulnerable to violence, such as a lack of a good education, adequate housing, awareness of their rights, and economic autonomy, and related grounds of discrimination such as disability, race, migration status, and many more. The committee has provided a comprehensive interpretive framework with its general recommendations, which have to be read alongside the treaty itself to understand the application of the articles. This body of interpretation extends protections well beyond the Every Woman Treaty draft. This framework provides an authoritative guidance to states and other stakeholders as to the obligations entailed by the articles of CEDAW itself. CEDAW is one of the most universally ratified of the human rights treaties. The 7 UN member states that have not ratified or acceded to the convention are Iran, Nauru, Palau, Somalia, Sudan, Tonga, and the United States. And we are aware that Sudan has indicated a willingness to sign on quite recently. No state has opposed the 3 general recommendations dealing directly with gender-based violence against women, nor any of the other ones also handling this issue. This normative framework has been recognized by all countries. Based on constant state practice, which is the standard for law, the committee stated that the prohibition of gender-based violence against women has evolved into a principle of customary international law. This means, in plain English, that all states, even those that have not ratified CEDAW, are required by the agreed upon principles of international law to fulfill the obligation to protect women against gender-based violence. This is a very powerful tool and puts gender-based violence at the same level as non-derogable rights such as the prohibition of slavery. On closer examination, the Every Woman Treaty's allegation that CEDAW and the international human rights system contain normative gaps does more to weaken the protection against gender-based violence against women ensured by CEDAW and by the UN human rights system as such than it does to strengthen it. The Every Woman Treaty appears ill-informed about the role of other treaty bodies that also deal with gender-based violence against women, as well as the special procedures created by the Human Rights Council. The Every Woman Treaty has devised a monitoring system for its proposed treaty that I will leave to my colleague Patricia to outline and discuss. For now, I will just clarify the basics of the CEDAW monitoring system so that the differences between what exists and what is proposed are outlined in basic form to be understandable. Likewise, because my colleague Marian Bethel will go into far more detail as to the work of the CEDAW committee, since she is best placed among us to do so, I will not elaborate this very, very deeply. Briefly, monitoring of states' compliance with the treaty is exercised by the CEDAW committee through the state reporting process and through individual communications, or what you might call cases, and inquiries into alleged grave or systematic violations based on what's called the optional protocol to CEDAW. That optional protocol grants individuals the right to gain a hearing when they have exhausted domestic remedies. The committee then arrives at a decision that can direct states to take measures to rectify the alleged harm. Its Article 8 allows for investigative powers into states' parties where systemic issues are credibly alleged. If the committee considers there were violations of women's human rights, it makes recommendations to the state concerned. Canadians in the audience today will be familiar with this provision, since it was what CEDAW used to prompt the Canadian government's requirement to conduct a national inquiry into missing and murdered Indigenous women and girls. In the state reporting process, the committee asks questions of the states to test their adherence to and need for guidance in order to fulfill their obligations. Following this, the committee adopts concluding observations and recommendations, including on gender-based violence against women, based on the general recommendations that I mentioned before. Concluding observation.
1 minute.
Sorry?
We will have to be wrapping up.
Okay, I'm almost there. Thank you. Concluding observations and recommendations are country-specific, detailed, and precise. They preempt the Every Woman Treaty proponents' criticisms of CEDAW, the so-called normative gaps that they refer to, such as requiring legislation, training, resources, shelters, data, etc. In conclusion, I want to make it clear that as a passionate advocate for women's human rights and a lifetime practitioner and activist in the gender-based violence space, I concur that more needs to be done to address gender-based violence against women. I'm currently advocating in my own country for a national action plan based on the framework set in international obligations delivered to our government by our National Shelter Association. I'm saying, however, very clearly that the passion and outrage marshaled by the Every Woman Treaty would be better directed at implementing, ratifying, and funding the existing legal practical framework instead of creating a new one, with all the risks of losing ground and dissipated energy that my colleague Patricia Schultz will detail. Another way to look at it is that there are many global protections that states are parties to that require adherence to protections against violence against women. Foremost among them is CEDAW. But like all 9 human rights treaties, it is a compact between states, and it is up to us as national women's movements to hold our state accountable to those agreements as part of our work. Thank you.
Thank you very much, Amanda. And now, please, join me in welcoming to the floor Patricia Schultz. Patricia, you have the floor.
Thank you very much, Patricia. I'm very happy also to be participating in this important discussion, and I'll speak to the politicization of the issue of gender-based violence against women that has been brought by the EWT campaign and their draft treaty. And first of all, I want to place that in the context of the negotiation of the future treaty, which is suggested. And I think that in addition to the analysis that Amanda Dale has made and the legal analysis of the false promises made by the EWT campaign, there is also need for this political analysis of the context in which this campaign is being led, in which the negotiations and then the monitoring of the new treaty would occur. First of all, a few general words. The campaign seems to operate in a political void, or rather in a fairy tale world in which there is no risk of provoking a drastic backlash in the present protection offered by the CEDAW framework should their efforts be successful based on the draft that has been developed. Indeed, we are currently experiencing a global backlash on human rights, and in particular on women's human rights, on the rule of law and democracy. And this has been going on for years. A significant number of states and non-state actors have allied to actively oppose women's rights. Some of the confrontation is against the universality of human rights and an attempt to empty gender equality and the fight against gender-based discrimination of its meaning. Negotiating a new treaty in this climate would give these opponents of women's rights the opportunity to limit the protection we currently have in place against gender-based violence, thanks to the CEDAW normative framework and the monitoring being made by the CEDAW committee. The EWT campaign seems completely oblivious to this grave risk, and let me give some illustrations, first of all, at the UN level of what happens. Their gender, sexual and reproductive health and rights, homosexuality, and women's full enjoyment of their human rights are attacked quite systematically by some actors. And I want to take you through the concept of gender and the way it developed and the way it is attacked. At the time of the adoption of the Universal Declaration of Human Rights, the two covenants on civil and political rights and on economic, social, and cultural rights, and the CEDAW Convention, the concept of gender was unknown in international human rights law. These international instruments refer to sex and sex-based discrimination, but their interpretation has led to the use of the concept of gender. In 2010, based on its year-long practice, the CEDAW committee gave the following definition of sex and gender, and I quote, "The term sex refers to biological differences between women and men. The term gender refers to socially constructed identities, attributes, and roles for women and men, and society's social and cultural meaning for these biological differences, resulting in hierarchical relationships between women and men, and in the distribution of power and rights favoring men and disadvantaging women. This social positioning of women and men is affected by political, economic, cultural, social, religious, ideological, and environmental factors, and can likewise be changed by culture, society, and community." End of quote.
Patricia, just a favor for our interpreter to go a little bit slower.
Okay, I will try. Gender is thus concerned with the unequal distribution of power between men and women. It helps us analyze the different forms of discrimination and violence affecting women and girls. It makes us understand that these forms are not nature-bound or God-given, but they are social and cultural constructions, and thus they can evolve. This concept of gender is used widely by the treaty bodies, the different human rights committees, in other words, the UN agencies, and also the Sustainable Development Goals. But however, there is contestation by state and non-state actors, and this contestation is very active. Indeed, although the concept is clear, some religious and other groups and states erroneously use the term of gender to refer to sexual orientation, and therefore they reject it. Some countries have thus removed school materials that use the term gender or gender equality. Those who want to uphold the idea of natural roles of men and women and a binary understanding of sex have also contest the use of this term, as the Vatican has been doing, at least since the 1995 Beijing conference. Some states and religious institutions and groups have accused what they call gender ideology of destroying the traditional values and the family. At sessions of the Human Rights Council, appeals to so-called traditional values and the protection of the family, composed of a heterosexual married couple with their children, have been made to oppose efforts to eliminate gender-based discrimination and violence against women and girls. These efforts were made, for instance, through resolutions led by Russia, but supported by many other countries, both secular and religious. Behind the scenes, or sometimes quite visibly, powerful actors such as the Vatican, some Islamic states, the Russian Orthodox Church, Catholic and evangelical USA groups, or even rich individuals support these retrogressive agendas. They are very well financed, much better than the civil society organizations active towards social, gender, and environmental justice. Women human rights defenders are also a target of a number of these attacks. At the European level, the contestation of women's rights is ongoing, and that addresses also gender. The Istanbul Convention on Domestic Violence and Violence Against Women also uses the term gender in the sense that I mentioned before. And according to Article 3, gender is here defined as the socially constructed roles, behaviors, activities, and attributes that a given society considers appropriate for women and men. Gender-based violence against women refers to all violence directed against a woman because she is a woman or that affects women disproportionately. End of quote. Now, what happened in practice? Turkey has withdrawn from the Istanbul Convention, alleging that, and I quote, the Istanbul Convention, originally intended to promote women's rights, has been hijacked by a group of people attempting to normalize homosexuality, which is incompatible with Turkey's social and family values, end of quote. Other East European countries are openly discussing following suit. For instance, Poland has envisaged to withdraw from the Istanbul Convention and to propose the adoption of a new treaty that would ban same-sex marriage and abortion, another example of conflation of gender with homosexuality and a further attempt to restrict women's sexual and reproductive health and rights. The Bulgarian Constitutional Court has declared that the use of the concept of gender was unconstitutional. In addition, these attacks against women's rights, including gender equality and the concept of gender itself, occur in a context of repression of other fundamental rights and freedoms, such as freedom of expression, association, and assembly, making it difficult or dangerous for the advocates of women's rights to express themselves and to do their information, communication, and lobbying work. Now, how to negotiate a treaty on gender-based violence if the concept of gender is being discussed in the way that it is being discussed by some actors is a question. The increased backlash and repression of human rights organizations and human rights defenders in numerous countries is definitely not a climate conducive to negotiating a treaty on gender-based violence against women and girls. In addition, such a negotiation would take years with confrontation, with no, as I mentioned, really no guarantee of a positive result. On the contrary, and it would use up the impulse, the activities, the energy of states and non-state actors and NGOs, instead of concentrating on the implementation of what exists presently at the national level and through the CEDAW framework. I now come to the plan monitoring system and the weakening of monitoring that this system would entail. The monitoring system suggested by the draft treaty is very weird. It would be the only one of its sorts among all the human rights treaty bodies. Indeed, it foresees a conference of parties which would be composed of representatives of the states that have ratified the treaty. Thus, unlike having monitoring by independent and impartial experts, we would have a monitoring by state representatives that defend the political views of their country. They would have no obligation to be impartial and independent. The draft treaty indirectly admits the weakness of its proposals, as it suggests that a roster of experts be designed to support the conference of parties, which is an admission of the lack of expertise of the representatives that would sit in this conference of parties. Recommendations adopted by the conference of parties would be much weaker, both substantively and in their acceptance by state parties, as political posturing would play a big role in the monitoring of the treaty, replacing the serious expertise by the CEDAW committee. In addition, the Every Woman Treaty campaign does not indicate how to handle the duplication that would occur should this treaty be adopted. Would states that ratify it report only before this conference of party and no longer before the CEDAW committee, although they would have reported to it for years? Could states refuse to go to the conference of parties? How many states would ratify this new treaty? That's another question. And how would states and all the others that participate in the reporting exercise handle this duplication? Also, one has to mention that other treaties also deal with violence against women under their own convention, and would they have to stop their examination of gender-based violence, or would they continue? Duplication, which is this obligation to report before different human rights mechanisms, is already criticized by many states. Attempts have been ongoing for years to limit it and to streamline the reporting obligations of states. One of the reasons being to avoid, also in addition to too much work, is to avoid having contradicting observations and recommendations. The Every Woman Treaty campaign hasn't addressed these questions. It also seems totally oblivious of the dire financial and staff situation of the treaty bodies and of the Office of the High Commissioner for Human Rights, OHCHR, suggesting that OHCHR would be and would have to be the secretariat of the Conference of Parties presents another huge risk, that of further undermining the capacity of the treaty bodies to deliver their work, since they would have to share their already insufficient resources, financial and personal, with the Conference of Parties. So on the basis of all these elements, I conclude that the Every Woman Treaty campaign and the draft treaty are misdirected efforts risking to gravely impair the present protection of the human rights, of the protection guaranteed by the international human rights framework, and CEDAW in particular, against gender-based violence. I was an activist in my youth. I became an institutional feminist during many years as director of the Federal Office for Gender Equality. I became an expert in the CEDAW committee. I worked on the second edition of the commentary on the CEDAW Convention, and I am again an activist in my old age. And in all these capacities, I strongly believe in the necessity to combat this misguided effort and to put all our energy, our dynamism, our commitment into the implementation of the CEDAW regional and national frameworks. Thank you.
Thank you very much, Patricia. That was amazing. And now please let us welcome Marion Bethel.
Yes.
Marion, you have the floor.
Yes, thank you very much, Patricia. I'd like to thank the Women Human Rights Institute for hosting this very significant session today, and to thank my presenters, my fellow presenters, Amanda for her legal analysis, and to Patricia for her political analysis. I will look at 5 aspects of the CEDAW Convention and Committee as we sit, and I'll call them, the first one is the conceptual framework of substantive equality and non-discrimination. And I want to spend some time on that because I think that is the framework within which we anchor gender-based violence. And I want to just explore that a bit. Then I'll look at intersectionality, and then access to justice, the role of NGOs, and then the coordinating mechanism that the CEDAW committee has now put in place to further guide states parties in regard to gender-based violence.
Sorry, Marianne, to interrupt you. All again, the same recommendation from our interpreter to go a little bit slower.
More slow. Okay, so I'm going to go very slowly because I speak rather quickly. All right. So CEDAW's conceptual framework. CEDAW's binding obligations in relation to gender-based violence emphasizes the links between gender-based violence and the denial of rights to non-discrimination and substantive equality guaranteed under CEDAW and other human rights instruments. CEDAW has a well-established body of jurisprudence and recommendations developed by the committee that establishes the connection or relationship of gender-based violence with other forms of discrimination. It has created a link between gender-based violence and other forms of discrimination that are a consequence of inequality within the global political economy and in local, economic, social, cultural, and religious contexts. In placing gender-based violence within the specific context of discrimination and substantive equality, the committee has highlighted new forms of gender-based violence and expanded the scope of state obligations to protect women against gender-based violence. This approach addresses the underlying causes and consequences of gender-based violence and calls for a comprehensive response by the state party to the issue. In addition, strategies for addressing gender-based violence must further strengthen the linkages between gender-based violence as a manifestation of inequality between women and men and other forms of discrimination. The convention defines the rights of women to be free from discrimination and gender-based violence and sets the core principles under General Recommendation 35, which updates General Recommendation 19, to ensure that states parties' obligations, responsibilities, and actions address gender-based violence. It establishes a basis and an agenda for national action to address the persistent nature of inequality, discrimination, and gender-based violence. Further, it provides a theoretical framework by which to identify both the root causes of gender-based violence and barriers to advancement in this area. The framework facilitates the assessment of needs, goals, and identifies measures to be taken for action by states. The framework establishes itself as a counter to the limitations of formal equality and to the inconsistencies of the application of the law, as well as the negative impact of social and cultural norms that prevent women from exercising their rights to substantive equality. CEDAW, therefore, has established a critical conceptual and ideological framework that places gender-based violence at the center of international and domestic discourse about rights and global inequality. This framework can help strengthen and effect the shifts required for social, cultural, and political transformation, which must work comprehensively in eliminating gender-based violence. In this light, measures taken by states parties must respond holistically to the current political, economic, and cultural environment. The CEDAW Committee, through its constructive dialogue with states parties, concluding observations and findings under the optional protocol, continues to address the normative gap and effectively respond to the wide array of challenges within the current political, economic, and social context linked to gender-based violence. The concluding observations of the committee and the findings or views guide states in their task and show them how to increase levels of compliance with the standards of CEDAW. The CEDAW Convention as a human rights treaty carries with it the strength and obligations that are legally binding on states, while also establishing a monitoring mechanism for individual state parties, as well as the possibility for individuals around the world to lodge a complaint to the CEDAW Committee. While some progress has been made in many countries in regard to gender-based violence against women, there is no denial that human rights violations exist in all countries and cultures to varying degrees in this regard. It is true that custom and culture often override considerations of state obligations under CEDAW. While the CEDAW General Recommendations 19 and 35 are not legally binding in themselves, the standards and extent of state obligations articulated under the general recommendations have been used as a tool by both states parties and women's rights organizations to advocate for state compliance to address and eliminate gender-based violence, and have been operationalized in state practice. By locating gender-based violence within the matrix of non-discrimination and substantive equality, General Recommendations 35 and 19 conceptualizes gender-based violence not only as a form of discrimination, but also as a consequence of structural inequality. Since the adoption of General Recommendation 19 in 1992, and General Recommendation 35 in 2017, states have reported on the measures that have been taken to address gender-based violence in their periodic review. A number of states have subsequently adopted legislative measures, policies, and national action plans to address gender-based violence to meet their obligations as articulated in recommendations made by the CEDAW Committee in the concluding observations and decisions in the optional protocol cases. Further, the committee repeatedly communicates its concern to all of the countries regarding gender stereotyping, the effects of which would be to impede women's full enjoyment of their human rights. Generally, the committee points to the persistence of adverse cultural norms, practices, traditions, patriarchal attitudes, and deep-rooted stereotypes regarding the roles, responsibilities, and identities of women and men in the family and in society. It notes that
Marian, I'm so terribly sorry to interrupt you again, but I'm having messages from Cassandra to go a little bit slower.
Okay, I'm really sorry, I regret. It notes that stereotypes contribute to the persistence of gender-based violence against women and practices harmful to women and girls, such as female genital mutilation, child marriage, domestic violence, rape, sexual violence in conflict situations. The committee expresses its concern that states parties have not taken sufficient, sustained, and systematic action to modify or eliminate stereotypes and harmful practices. In regard to intersectionality, Strategies to address gender-based violence must be focused on framing responses that aim to address the rights contexts of the most marginalized women. These strategies must enable the meaningful inclusion of their voices and activism. CEDAW recognizes and addresses the multiple layers of discrimination faced by marginalized women with intersecting identities. More work needs to be done to ensure the women's movement itself is more inclusive and women from marginalized groups meaningfully represented at all levels. This requires reflection and recognition of the structural inequalities and discrimination that exist within each society and the women's rights movements in itself. In addition, there needs to be greater collaboration between the women's human rights movements and other movements, including groups of women, migrant workers, refugees, lesbians, transgender persons, sex workers, Indigenous women, women of color, in sharing knowledge on strategies to address gender-based violence against women, and linking standards between different international human rights treaties and instruments. CEDAW has a very strong position on intersectionality in its program. Access to justice. Compliance with CEDAW reaches far beyond the enactment of laws. It also requires an enabling environment for women to seek justice and hold states accountable. Despite progressive laws to address gender-based violence, justice systems and law enforcement institutions and agents, the police, prosecutors, and judges are often not resourced or capacitated to respond to the needs of women and other vulnerable groups. At the domestic level in many countries, the survivors of gender-based violence reveal that while gender-based violence laws and policies are in place, the lack of understanding, awareness, training, and resources mean that the necessary protection and redress are not available. Institutional biases and prejudices, as well as corruption within these national institutions, perpetuate a culture of impunity and the normalization of gender-based violence. Stereotypical assumptions caused by patriarchal culture related to gender norms and roles continue to discriminate against survivors of gender-based violence in their right of access to justice. So laws alone are not able to address these issues. We need measures related to capacity building programs for public officials, such as gender sensitivity training for the police. Further, gender-based violence needs to be prioritized as a political issue within governance structures to include resource allocation, spending of budget, and ensuring meaningful participation and representation of women. I now come to the role of NGOs. Women's NGOs and national movements are key actors in pushing for state accountability for gender-based violence under CEDAW. The gains that we've made so far at the international and national level were achieved with the strength and force of the women's movement in exerting political pressure on states to address gender-based violence as a serious human rights violation that requires urgent action. NGOs have used the concluding observations of the CEDAW committee to advance this cause. Gender-based violence as an issue needs to be analyzed and reprioritized within the global, national, and regional political and economic contexts. Strategies in holding states accountable for gender-based violence must catalyze the political will of states to prevent and address gender-based violence as a priority issue. The women's rights movements and NGOs must continue to challenge harmful practices and gender stereotypes to justify gender-based violence on the basis of culture, tradition, and religion. The CEDAW reporting mechanism provides for NGOs and women's rights organizations to organize and attend constructive dialogues, to submit shadow reports in regard to the official state report, thereby supplementing the work of women's rights organizations at the national level in creating pressure on states to take measures towards addressing gender-based violence against women. And let me say very clearly that the shadow reports that NGOs submit to us in regard to our constructive dialogues or when we are drafting our list of issues for states parties is critical to the work that we do. We depend and rely heavily on these submissions by NGOs to help us with our constructive dialogue and with framing questions for the states parties. So implementation of international human rights standards aimed at changes in laws, policies, as well as culture to address human rights violations still rests primarily on the political will of the state, which ultimately responds to political pressure created by NGOs, women's NGOs, and citizens. And so the role of NGOs is critical to the implementation of the compliance with the CEDAW Convention. And finally, I just want to look at this, how the CEDAW Committee coordinates and integrates the work of all international mechanisms that have a stake in gender-based violence against women. So at this time, the committee has established a standing working group on gender-based violence against women that is developing an in-depth document that will provide further guidance and aid to ensure the applicability of the substantive equality standards of the convention to promote and protect women's rights to substantive equality and to ensure that the rule of law protects the human rights in regard to gender-based violence in order to advance the fulfillment of states parties' obligations under CEDAW. To further develop an intersectional approach to gender-based violence at the international level, the committee has established cooperation with other UN human rights treaty bodies and special procedures through a platform called EDVAW, EDVAW, which is the Expert Mechanism for Discrimination and Violence Against Women platform. This includes a special rapporteur on violence against women, its causes and consequences, the Council of Europe, the Working Group on Discrimination Against Women and Girls, the Inter-American Commission on Human Rights Rapporteur for Women's Rights, the Special Rapporteur on the Rights of Women in Africa, and the Committee of Experts of Belém do Pará Convention. We will continue to strengthen the international standard setting by increased collaboration with other entities such as the Human Rights Council, the Security Council. We have often worked with the Convention on the Rights of the Child and the other covenants. Special rapporteurs such as the Special Rapporteur on Poverty, the Special Rapporteur on Migration, and the Special Rapporteur on Slavery in order to facilitate stronger linkages between gender-based violence and other forms of discrimination and to elucidate gender-based violence's more structural causes. So this standing committee is developing this concept to provide states with further guidance as to how to address gender-based violence and from a structural and political point of view. So I want to stop there, and I think my time is up in any case, and we can go to the question and answer discussion part of our conversation. Thank you very much.
Thank you very much, Marian. Thank you so much. And well, now it is my pleasure to request Alda to respond as discussant with her comments and questions for our panelists. So Alda, you have the floor.
Alda, are you there? Your microphone is on mute if you're speaking to us.
Okay, I'm sorry. Good morning, everyone. And I just was, before asking the questions to our fantastic panelists who were very clear, I would like to clarify that in the interpretation, substantive, what is something is, oh, again, this is today's, okay, the I would like to
Mm.
I'd like to clarify that substantive equality in Spanish is not equidad sustanciosa, es igualdad sustantiva. Y I will speak in Spanish for a few seconds just to clarify in Spanish what substantive equality is, que es muy diferente y en la CEDAW y las defensoras de derechos humanos hacemos mucho énfasis en que no son sinónimos la equidad y la igualdad. O sea, se habla en la CEDAW habla de igualdad sustantiva. So I was just clarifying that it was incorrectly translated, the substantive equality, which would take me to one of the questions that I would like for any one of you to clarify a little bit. What is the connection that all of you mentioned it, but what is the connection with substantive equality and non-discrimination and the right to a life free of violence, which especially Amanda referred to very clearly, but sometimes this is such a new notion and a controversial notion sometimes that we need to really make the links in legally and conceptually. And also for Patricia, I would like you to make the link. You said something really very important, I thought, about if we have if we separate or we take out gender-based violence from the and separate it from the substantive equality and non-discrimination, then would this mean that states would not have to report on violence against women when they're reporting to CEDAW? And if they haven't ratified this new treaty, then that makes them that they don't have to report on violence at all to any body. So that is one thing that I would like for you to talk about, and Marian also to explain, if you could give us some examples of how NGOs work together with the committee. How do you get to be involved with it or know what the NGOs from a country that is reporting, what are they thinking, and how do you guarantee that you listen to different NGOs and not only one big NGO from the state? And to all of you, but especially to Patricia, what is the importance of independent experts in the CEDAW committee compared to state representatives, as what this Every Woman's Treaty is suggesting? And I also, before you answer these questions and any other that you can ask to each to among yourselves, I would like to say that the reason we held this webinar is that we want more NGO involvement with CEDAW, not less. We're not saying that CEDAW should, NGOs should not even suggest new treaties or way. We're just trying to show that this is not, and I think that Amanda said it very clearly. You see the passion and the involvement of the NGOs that are calling for a new treaty, but we are absolutely convinced that a new treaty is not the way to go. And so we think that it is very important that we are very clear about this, and that before we think of, because all the time this is happening in the UN, there's calls for new special procedures, new treaties, etc., and why this weakens the present structures, and how can we work better to include the issues that are called upon from the NGOs. And also, any of you could talk about like the false promises of this campaign for a new treaty, because it seems to say that all we need is a new treaty, and with a new treaty, then we will have enough resources, we will have states reporting. Why is this not true, or they're false promises? Thank you. I will leave you to answer these questions.
Thank you so much, Alda. And to remind you that we have a 20-minute framework for this portion of the webinar. And I don't know, Patricia, if you want to jump in. I've been told that Amanda is reconnecting now.
Yeah, gladly start. I'll start with the last question. What I see as a really a big problem with the promises made by the campaign, the Every Woman Treaty campaign, is that it gives a false picture. It's as if the minute you have this treaty adopted, then states would comply with it, and they would give all the money that is needed, and they would train all the people that have to be trained, from the police to the Supreme Court judges, and all the health personnel and the social services and all the people in education, etc. So I really think that, I mean, if this kind of compliance were what happens in general, we would know it, because all of the present human rights conventions would be applied 100%. And we know that it is not the case with human rights conventions, but we also know that it's not necessarily the case with the national legislation that is there and the guarantees given in the national constitutions. So let us not believe this fairy tale. This treaty would be as well or as poorly implemented as others. So that's my first answer. And that's why I really think that what we need is, as Marian underlined, is coordinated action at the national level, at the international levels, with civil society trying to do its best to push countries to move on and to do what they have to do. Now, as a former member of the CEDAW committee, I often noticed that there is this call for more laws, more norms, new norms. And my experience, I was the director of the Federal Office for Gender Equality of Switzerland during 16 years. And there, what I noted was, let us apply, implement what we have. If we did that in a very coherent and consistent way, we would have great progress. New norms are not necessarily an improvement on what we have. So that's to answer the question that were posed. And I think I would like to say a word on the importance of independent experts compared to state representatives. Well, it makes a world of difference whether you have an agenda coming from your state, or you look at a situation as an expert, an independent expert who receives no instructions from anybody, and who is ready and willing to discuss with a state delegation on in an open discussion, and to make the best recommendations for that country without a political agenda as first and foremost. And I'm not saying that experts don't have ideas, of their own ideas, but they have sworn to be impartial and independent, and that's a guarantee that no state representative of this conference of parties would have to give, not planned.
Okay. Thank you, Patricia.
Thank
Yes.
you, Patricia. Amanda, do you want to add to this?
So I'm apologies. I lost connectivity. I'm in rural Quebec, and my internet is a little unstable. So I'm not on video in order to not lose you again. So the question that I heard just as I fell off was from Alda regarding the link between a definition of substantive equality and violence against women and the protections against violence against women. And I guess, you know, in a simple way, you could define substantive equality. It's usually defined in opposition to what is called formal equality. And this gets to the heart of what Patricia was just saying, that there are many good laws on the books in many countries, not all countries, but in many countries. So for instance, in Canada, whenever I am in international fora, people always sort of roll their eyes and say, oh, well, Canada, what do you have to worry about? You have great laws. But the fact of the matter is that Canada has been investigated by CEDAW for grave and systematic violations of women's human rights because of the levels of violence against Indigenous women. So how do those two things go together? Well, substantive equality is a partial answer to that. It means that you can't just have on the books a notion, as Patricia called it, a fairy tale of equality. You have to substantively alter the conditions in which those laws are on those books in order to ensure that women have access to that promised equality. And that is not primarily an action of law itself. And this is, I think, one of the gaps in our thinking, that often the first step is to create laws that recognize differential access to justice, to equality, to the right to, you know, fair and equal representation. And that differential access has to be addressed socially. And that's why we have movements. That's why we have people holding states to the standards that they set in those laws. So it's not simply a matter, as Patricia said, of adding more laws that sound good. It's about using what laws there are on the books and ensuring compliance with them, which is a much deeper activity. Trust me, most lawyers love going to the Supreme Court and getting a ruling that extends the standard of equality in some way. But are they then leaving the podium at the Supreme Court where they've made an hour-long submission and spending 25 years making sure that that actually happens in real life? That's movement-based work. And that's the work that needs to happen with CEDAW in hand. We need to rattle CEDAW at our governments in effective and strategic ways, not just at the shadow report, but between those reports, between those 4-year cycles. We need to be using that obligation as a tool for what we ask for domestically. Likewise, using what we advocate for domestically helps CEDAW, as Marion said earlier, helps CEDAW be clear about what the national women's movements are seeing in their actual context. So the state is always going to come to CEDAW and say, we're doing great. Since we were last here, we enacted this law, that law, the other law. We implemented this, we did that. And I know this very well from monitoring Canada's compliance, which is a state that in the global context is quite a bit further along than some on its legal framework. But is the implementation happening substantively? And that's the question that I think Alda has asked us to address.
Right. All right. And I think from there, I'll just thank you very much for that, Amanda and Patricia. And the question that was specifically posed to me was about the role of the NGOs. And Amanda, you left off talking a bit about that. And so I just want to say very, forcefully that the role of the NGOs is critical to the work that CEDAW does at every stage of the work that we do, not just during the constructive dialogue itself, where NGOs are in attendance and where we have a meeting with NGOs prior to the the night before the constructive dialogue, we meet with them and have a very deep conversation about the reports that they've submitted to us. And we interrogate and try to clarify based on what the NGOs have said and also what the state party report has to offer. And so by hearing from the NGOs, we get to know what's going on the ground in a specific country. And as Amanda said, that the state party tries to put forward its best face. And so the state report does not necessarily give us all that we need. And so the work of the NGO day in and day out in a shadow report to us on gender-based violence in particular, but also all of the other aspects of the convention is very important for the work that we do. And so there are at least two periods within the reporting process that NGOs can submit to us shadow reports. And one is prior to the actual constructive dialogue, but also there's another opportunity even before the constructive dialogue where we sit and draft as a committee what's called a list of issues. And it is there that we also need input from NGOs in order to help us frame the kinds of questions that we ask NGOs that we send to NGOs, and they then send us back a written report just prior to the constructive dialogue. So the work of NGOs is fiercely important. We really ask you to consider always to send us shadow reports in regard to the work that you do. And we're talking about gender-based violence at this time. So specifically around gender-based violence, implementation of laws, the challenges that the country is facing in terms of perhaps the weakness of the law or just the implementation and the challenges around that. It's really important for us to know all of that so that we can then frame the kinds of questions to the state party, the delegation that is there, that we can get the kinds of responses that we need to then frame the concluding observations that are the helpful points for the state party to go away and work with. Thank you.
Thank you, Mary. And Patricia, you wanted to add to that?
Yeah, I want to apologize. I forgot to address directly the question directly addressed to me on whether states would stop reporting to the CEDAW committee should they ratify this new convention, or even if they didn't, would they stop? I really don't think so, because there has been no contestation by any state of the competence of the committee to address violence against women, gender-based violence. So that I think that since now we see that the prohibition of gender-based violence is a norm of customary international law, I don't see any state daring to not answer the CEDAW committee's questions on the implementation that it does of this protection against gender-based violence. So the issue is more for states, if they ratified this other treaty, that they would have to report to the two mechanisms, but not that they could stop reporting to CEDAW. Definitely not.
And I guess a practical question that is related to that is sort of implied by Alda's question is that, you know, the issue of violence against women is embedded in all of these other forms of discrimination. And to report on it without those other forms of discrimination seems quite abstract and not possible in real life. So how do you talk about, for instance, Indigenous women's experience of violence in Canada without dealing with the other forms of discrimination under the other articles, such as education, access to healthcare, et cetera, et cetera? So that's one aspect of the reporting that I think would be practically challenging. But you know, another matter is that the issue of gender-based violence and the frameworks that exist in all of the other treaties to deal with the issue of violence, requires, I think, expert knowledge on the integration of all of those other bodies. Because a state could be reporting one thing to one treaty body and another to another. And I think that coordination role that CEDAW has played, because it is part of the family of the international human rights treaties, which are all based on a discrimination framework. That is the legal framework. That it has an understanding of that coordination. The issue of violence against women, interestingly enough, has been contested by some activists outside of the UN as being too much of a focus of CEDAW, that CEDAW focuses too much on the issue of violence against women and not enough, for instance, on economic violations. So quite contrary to the claims of the Every Woman Treaty, the jurisprudence of CEDAW, it tells a very different story. So a deeper dive into what CEDAW is actually focused on shows a predominance of concern with the issue of violence against women.
Thank you, Amanda. Alda?
Yes, we're getting very close to the end of our webinar, but I want to really say that this has clarified so much, not only on violence against women, but what CEDAW can and cannot do. And I think it's very important for all of us to understand that even the limitations that CEDAW does have, the CEDAW committee does have limitations, and Patricia talked about some of them, and we have to see how we can strengthen, instead of thinking of creating new mechanisms, new treaties, and everything. Then it's how do we empower and enforce what we already have? So thank you very much. You were all incredibly clear, I thought, and it was difficult to ask questions because you were all, everything was very clear. So thank you very much to the three of you, and to all the organizers, and to Patricia Yepes for the welcoming remarks. Thank you very much.
Thank you very much, Alda, and thank you to all the participants. Now our time has come to end for today. I would like to take this moment to thank all of our panelists for these important insights and for sharing their passion for CEDAW, the Every Woman Treaty that already is. Thank you also, Cassandra, who has provided live interpretation at this session. We hope you all continue to engage with us on this important topic, and remind you that we will send a follow-up email to all registrants with a link to the paper authored by Amanda and Patricia, which has just been translated into Spanish. The recording of the webinar will also be made available in the days ahead on the WHRI YouTube channel, and is archived on the WHR Facebook page. Thank you very much, and thank you for attending.